Good morning and welcome to all participants who have registered for the Anti-Corruption Law Program webinar today. My name is John Ritchie. I work together with my colleague and friend Joe Weiler as co-director of the Anti-Corruption Law Program. Joe is Professor Emeritus at the Peter A. Allard School of Law at UBC. Both of us have served on the board of Transparency International Canada. Joe is a current member of the board. The ACLP is a working partnership of three entities, each of which has a different core competency. The Centre for Business Law at the University of BC is one of our key partners, Transparency International Canada, and now the recently established Vancouver Anti-Corruption Institute, which functions under the overall management of the International Centre for Criminal Law Reform, or ICLR, which is also headquartered at UBC. At this point, I'd like to acknowledge and thank Dr. Carol Liao, Director of the Center for Business Law, and her great technical team at the CBL, which is led now by Dr. Lachlan de Jong, who is working behind the scenes on this event, along with his support staff. These webinars would not be possible without the team's able technical support to manage the technical aspects of it, the presentation of the webinar itself, and also the registration. A special thanks as well goes to James Cohen, Executive Director of TI Canada, and to Susan Côté-Freeman, who is Chair of TI Canada. You'll be hearing more from Susan later at the closure of this event. And also, of course, we want to acknowledge and thank Dr. Peter German, who is President of ICLR and Chair of the Advisory Committee of the Vancouver Anti-Corruption Institute. The ACLP was established in 2016 as a form of collective action locally here in Vancouver to allow interested professionals to educate ourselves in Vancouver on issues related to anti-corruption law. We began back in 2016 by organizing a series of free in-person seminars located in downtown Vancouver. We held 20 seminars until late 2019. And of course, like many others, we found that the COVID-19 pandemic had to change our operating model. And so we went to online webinars starting in early 2021. These webinars have been well received, and the webinar format has allowed us to bring in panelists from all over the world and to reach participants all over the world. This has been very gratifying. Today is the 14th webinar that we have offered since early 2021. Now, today's webinar is a third in a series of 4 webinars to discuss the key recommendations of the Commission of Inquiry into Money Laundering in British Columbia, which is also known as the Cullen Commission. The Cullen Commission presented an 1,800-page report based on testimony from 199 individuals and organizations. It's a very comprehensive document, and it's considered by many to represent a watershed moment in anti-corruption law reform in Canada. So we felt that we had to devote more than one webinar to the Cullen Commission Report. So the first webinar, which was held on September 19th, was addressed the topic of improving private sector self-regulation in British Columbia, which refers to self-regulation of lawyers, accountants, real estate professionals, and so on. The second webinar, which was held on October 31st and was led by TI Canada, reflected on how the Commission's recommendations may affect beneficial ownership transparency in Canada. Today's webinar will address the Commission's recommendations related to unexplained wealth orders and how they might be implemented here in BC. The webinar was organized by Dr. Peter German of VACI and ICLR. Dr. German could not be with us today for this webinar, so we're very fortunate that Peter Dent has stepped in to serve as our panel moderator. Just to mention, the fourth webinar, which will be held on January 19th, will address the Cullen Commission's recommendations for institutional reform within the government of BC, institutional reforms to address money laundering. So now getting back to Peter, Peter is a partner in Deloitte's financial crime practice based in Vancouver, has over 28 years of experience with financial crime, working with law enforcement and the World Bank before joining Deloitte. He works with clients conducting internal investigations and providing advice on anti-fraud and anti-corruption measures. Peter is a former chair of TI Canada, where I met Peter for the first time when I was a member of the TI Canada board. Now I'd like to pass it over to Peter. We're looking forward to a very interesting day. Thank you.
Thank you very much, John. And it's a pleasure for me to be here today. I'm honored to have been asked by the Centre for Business Law, Transparency International Canada, and the Vancouver Anti-Corruption Initiative to moderate this panel. We'll all be missing Peter German today, who's enjoying his time on a cruise ship right now. So I don't know how much he'll be missing us. But I'm joined by an esteemed panel, and I'll just give a brief introduction of each so that we can launch right into the content and what everybody showed up this morning for, or this morning, this afternoon, or this evening, depending on which time zone you're in. So first on the list is Jeffrey Simser. He's a former legal director for the Ministry of the Attorney General. He is joined by Stefan Cassella, who is the principal of Asset Forfeiture, LLC. We're happy to have Maria Nizzero here as well, and she is a research fellow for the Center for Financial Crime and Security Studies at the Royal United Services. And then Andrew Dornbierer, who's a senior asset recovery specialist at the Basel Institute for Governance, or on Governance. So thank you very much, each of you, for joining us today. And what I'd like to do is, the way we've organized today's seminar, of course, you can ask questions throughout. There's a Q&A bar that you can use to ask questions. I'll be seeing those as the panelists are providing their opening remarks. And then we'll get to those when we can. Some of them might be answered by our conversation with the panelists, but each of them is going to spend some time giving some introductory remarks. We're going to go through a general sort of roundtable discussion with myself, and then, of course, there'll be time for us to answer any questions that are coming through the Q&A as well. So, Jeffrey, we'll start with you, and I'll turn it over to you. So thank you very much.
So good morning to everyone on the West Coast. For us here in Central Canada, it's midday, and for our European colleagues who have joined us, it's early evening. And I'm really honored. This is an amazing panel. Hopefully, as we go through the webinar, you'll see that. And I would just say at the outset, for those who are really interested in what we're going to talk about, Andrew and I authored a paper earlier this fall on the subject. You can find it on the Basel Institute of Governance, and it was promoted through the Vancouver Anti-Corruption Institute. I'm grateful to Dr. German for bringing me into that project. What I'm going to try and do is just set the Canadian context for the discussion, and that can bring in the international experts, and we can sort of have a common ground for talking. And so for those of you who don't know, in 2019, the government of British Columbia struck a judicial commission of inquiry, much like the one in Ottawa we're seeing now, the Public Order or the Rouleau Commission. And Mr. Justice Cullen oversaw that commission, and a commission of inquiry into money laundering. What a rare and fantastic thing that was. There were 199 witnesses called before the commission, including Steph and I, my colleague Stefan Cassella and I as experts. There were 133 hearing days and over 1,000 exhibits. And as John noted, this past June, there was an 1,800-page report that included 101 recommendations to the Attorney General and the government of British Columbia. And the last of those recommendations, number 101, was UWO, or Unexplained Wealth Orders. And we'll unpack what that means in the course of the seminar, but just to give you a thumbnail to start with at least, basically what a UWO could be for British Columbia is an information gathering tool that would be used by BC's Civil Forfeiture Office. And they would go into court and they would ask the court to order a respondent to disclose the nature, the extent, the origins of any particular given piece of property, what was the source of wealth that bought it, that sort of thing. And failure to comply with that court order could give rise to a rebuttable presumption that could be used later in a civil forfeiture proceeding. So as a Canadian panelist, I thought I would just broaden the lens just slightly and take you across Canada and say where UWOs might also be useful. We do have one, and I'll talk about it at the end of my talk, already in Manitoba. There are 9 provinces and territories in Canada that have a civil forfeiture statute. And you may hear Maria and Andrew at some point talking about NCB forfeiture. It means civil forfeiture. It's non-conviction based forfeiture. The nomenclature internationally tends to be slightly different. Ontario's Civil Remedies Act was the first civil forfeiture statute. I had the good fortune to work on that, and it was passed in 2001. And I actually worked with folks in BC prior to the passage of their statute, the BC Civil Forfeiture Act in 2005. And I just observe right now the state of things in Canada. BC and Manitoba, I think, are the leading 2 civil forfeiture jurisdictions. I will note just briefly for you a federal statute, SEMA, or the Special Economics Measures Act. This may tie into some of the things Maria will talk about with oligarchs. That's the Canadian statute that's addressing oligarchs. We've frozen, I think, something in the order of $120 million in assets. That pales beside the UK number. And we've blocked about $300 million in transactions. Earlier this year, the federal government amended the statute to allow for an NCB forfeiture of those assets. But I would just observe to you, and we might not have a lot of time to get into this today, that those amendments were very hastily drawn up. And I sadly predict that we will never see a forfeiture of any of those assets here in Canada. And there's a lot of reasons for that. And again, I suspect Maria may have an insight into some of those for you. So to return back then to British Columbia, so the BC Civil Forfeiture Statute creates a statutory position, a director who oversees the program, and that director can go into a court, a civil court, and seek an IPO, or an initial preservation order. And that's an order from the court to freeze or seize 2 kinds of assets. And again, I'm being very reductive in the interests of time. The first is a proceed. That's property that has its provenance in unlawful activity. And the second is an instrument. That's something that makes the labor of the unlawful activity possible. So if you scroll through the Cullen archive, and it is an incredible resource, I will tell you, and it's still up, it's under cullencommission.ca, buried in there are evidence photos, one of which shows a safe at Silver International in Richmond, BC. And that safe is absolutely crack jammed full of Canadian banknotes. There are bricks of 20s and 10s and 50s. So for civil forfeiture, and there is actually a civil forfeiture case involving those banknotes, the banknotes we know from the evidence are probably coming from drug proceeds in the Greater Vancouver area. That's a proceed of unlawful activity. The safe itself, which the bad guy needs to secure his money, is the instrument. We don't know how it was bought. It really doesn't matter. It just makes storing that money possible. So what the director will first usually do is go into court and seek an IPO, or an initial preservation order. And they just simply have to convince the court that there's a serious question to be tried. Is this cash a proceed? Is that safe an instrument? Once that's in play, generally, and again, litigation can move in many directions, the civil litigation process kicks in, the director can go by action or application, there'll be discoveries and so on. And at the end of the day, the director is asking the court to forfeit the property. And so what the court is asked to do is, on a balance of probabilities, on a civil standard of proof, is it more likely or not that that cash, those bricks of cash and that safe are proceeds and instruments of unlawful activity? And then the court, once it forfeits it, it extinguishes the interest of the guy who owned the safe, and it becomes the property of the province of British Columbia. There are some safeguards in the statute. For example, the court is given a statutory judicial residual jurisdiction to refuse to make an order where to do so would clearly not be in the interest of justice. So that's where their order would result in something that was manifestly unjust or inequitable. And the court does have a number of rebuttable presumptions. We'll talk maybe a little bit about this later, because that was one of the questions Mr. Justice Cullen asked me about, sort of what does the statute need? It's actually pretty good. If you're in a car fleeing police, there's presumptions. If there's cash in your car, there's presumptions. If you've been convicted of a criminal organization offense in the criminal court, there are presumptions that come up. Now, the issue that brings this all together for a UWO perspective, in fact, comes around information and privacy. So the director has powers under the statute to collect information from the RCMP or the Vancouver police force. They can collect the file brief and then work on it and act on it. The director also does have a statutory power to go to court and seek information from a third party. And they've added, and I'm not sure how well it's been used, but they've added a power to also give a notice to financial institutions, I beg your pardon, to produce information. What Cullen found at the end of the day, and his 35-page synopsis is really useful and readable, is that money laundering in British Columbia had grown unchecked for more than a decade, mostly because of the inattention of the police, particularly the RCMP. And having worked in forfeiture for quite a while, I will tell you that this business is not necessarily rocket science, but you do need at the start, at the outset, expert investigators. And that expertise takes time to develop. And one of the problems that resulted from that inattention is that we've atrophied that base of expertise in the police in Canada and in BC. Cullen did hear significant evidence around how to quantify money laundering in BC. At the end of the day, he found he couldn't land on a number, simply that billions of dollars had flown through and had been laundered through British Columbia. But I should note for folks in other parts of Canada that this is not a BC problem. In fact, it's probably worse. At least BC is starting to do things. In Ontario, we're not. And one of the things that was observed several times in the Cullen Commission is that organized crime, kleptocrats, corrupt individuals go to lower risk jurisdictions all the time. And we are actually creating a situation in Canada now where BC will be slightly higher risk and places like Ontario, lower risk. So it actually may displace some of the problems into central Canada. Cullen also found that we have an anti-money laundering system in this country. It costs us $6.5 billion a year to run. It's run largely through a regulator, an agency, a federal agency called FINTRAC, which internationally would be known as a financial intelligence unit. And what Cullen found was that agency is simply not fit for purpose. It collects millions and millions of records from banks, financial institutions, and so on, and then produces very little actionable intelligence. Again, information is at the center of why a UWO is in contemplation. We also have a very truncated and siloed system in Canada, and that's for reasons, jurisdictional reasons, constitutional reasons, and so on. So there's provinces, there's federal, there's different agents, there's 13 different federal agencies that have some responsibility for anti-money laundering. But what that does is it creates a problem that I would call informational asymmetry. So law enforcement and the people that can actually do something about problems, whether it's a corrupt kleptocrat or a drug dealer in Vancouver, don't have the information that they need. And the last thing I would observe to you is this, that in British Columbia and for all civil forfeiture jurisdictions, the director of the civil forfeiture office takes a case as it comes to them. In other words, they cannot reach back into a police organization and say, well, could you surveil this guy or could you conduct a warrant on someone else? Those are adjunct to the criminal justice systems, and they've got to be kept separate, which is the last thing that I just wanted to observe in terms of the informational asymmetry. So just to sum up, as my time's up, Cullen saw the UWO proposal as a way of overcoming some of those structural challenges that we have in Canada.
Thank you very much, Jeff. That was very helpful in terms of setting the stage for the rest of our conversation this morning, this afternoon, this evening. So I'm going to move to Stefan, because one of the things when you're talking to a Canadian, many of the times what the discussion becomes, oh, what are the Americans doing? What's happening south of the border? And it seems to be that they're having a lot more success than we are in Canada, because we're always reading about all of these high-profile, illicit financial characters being taken down, going through court. Sometimes they're winning in court, sometimes they're losing in court. But Stefan, why don't you sort of give us the lay of the land south of the border on this topic? Yeah, you've got to take yourself off mute, Stefan.
Yes, thank you, Peter, and thank you for inviting me to this. It's encouraging to hear that you view the activities going on in the United States as being successes. I was afraid you were going to say that the answer to the question, what are the Americans doing, is nothing good. That's encouraging to hear. As you've heard, my perspective is that of a federal prosecutor who handled asset forfeiture matters in the United States for a great many years. And so my contribution is to sort of look at the issue that we're talking about today from the U.S. perspective. To state the obvious, if someone is convicted of a serious offense that generated a lot of illegal income, whether that be a drug offense, fraud, public corruption, or whatever, we, the government, want to recover the proceeds as part of the punishment for committing the offense. And if there is a victim, to return that money to the victim. That is standard criminal forfeiture procedure in the United States, as I'm sure it is in Canada. There are cases, however, where we want to recover the proceeds of a criminal offense, even though we cannot obtain a conviction. For example, the offender is deceased. He is a fugitive. He committed the crime in one country and then invested the proceeds in another. He's beyond the jurisdiction of the courts in the place where the property is located, and so forth. That is where civil or non-conviction-based forfeiture plays an essential role. In those cases, we can, as Jeff has suggested already, recover the proceeds of the crime without having to bring a criminal case, as long as we can establish, on a balance of the probabilities, the connection between the assets and a crime. That is, we can recover the proceeds as long as we can do three things: prove the crime, locate the defendant's assets, and then tie the assets to the crime. Now, there are many examples of how this has been used. One of the most prominent and perhaps most relevant to our discussion today is where you have a politically exposed person in a developing country who has invested enormous resources in another country, such as Canada or the UK or the United States. And the latter country then uses civil forfeiture as the vehicle for recovering the money and returning it to the country or to the victims where it belongs. They'd use civil forfeiture because in that situation, they cannot bring a criminal case against the individual who is elsewhere. So one way to do this, and I will call this the conventional approach, is to prove the crime that generated the wealth and show that it was used to acquire the assets. But this may be difficult to do. It's difficult enough when you're dealing with a purely domestic crime, whether it be a public official or anyone else who has an ostensibly modest income, and then seems to be living beyond his means, but he has done an effective job of obscuring the connection between his wealth and any illicit source of the money. Those cases are not necessarily easy to prove, even though we're talking about the civil balance of the probability standard. But the problem can become insurmountable when dealing with a foreign person and a foreign crime. How, for example, would the United States, for one, prove that money invested by a Russian oligarch in the United States was derived from a crime committed in Russia, whether it be public corruption or fraud or embezzlement or anything else, without Russian evidence? And what is the likelihood that Russia would provide such evidence? So the benefit of an unexplained wealth order, to get us to the focus of our discussion today, is that it offers a solution to this problem. The idea is that instead of putting the onus on the government to prove that a crime was committed and that the property was derived from the crime, it puts the onus on the person who seems to be living beyond his means to come forward with an explanation to show that he has a legitimate source for his money. And if he cannot show that, if he cannot explain the source of his wealth, then the money can be confiscated, even if the government cannot prove that he has committed a criminal offense or that his money was derived from any offense that he may have committed. In other words, it makes the person's inability or his unwillingness to explain the source of his wealth as the basis for the confiscation of his property. Now, that is obviously an attractive alternative to law enforcement, an alternative to the conventional approach. But it is something that we do not have in the United States. Instead, we have something of a hybrid. So I should explain that. Under federal law in the United States, unexplained wealth standing alone is not a viable ground for recovering criminal proceeds or returning it to victims. However, we do consider the person's inability to explain his wealth to be an appropriate factor, along with other evidence, in determining whether he's committed a crime and whether his property is connected to that crime. The question is, how much of a factor should it be, and what other evidence should be required before it applies? The essential problem from the perspective of policymakers and legislators in the United States with a unexplained wealth order is that it conjures up the image of the state going up to an apparently wealthy individual, whether or not he's suspected of committing a crime, and saying, explain where this money came from. And I suspect that most people in our country would say the appropriate response to that would be none of your business. The concept, in other words, runs counter to the view that people who obtain wealth are entitled to obtain it in any way they want to, as long as it's by legal means and as long as they pay their taxes. And it's none of the government's business how they earned it, unless the government first establishes that they committed a crime. So the caveat I mentioned, that as long as they pay their taxes, does give the government one way of looking into an otherwise law-abiding citizen's source of income. Tax evasion is a crime. And a person who acquires significant assets presumably has a source of income. And if not paying his taxes is what has happened, then he's guilty of a criminal offense. But tax evasion aside, we generally take the view that acquiring wealth is an inalienable right up there with life, liberty, and the pursuit of happiness. And it's none of the government's business how it was accomplished. And if the government wants an explanation for someone's wealth, it has to first present some evidence that a crime was committed. But here's the point. While simple possession of unexplained wealth is not enough by itself to justify a confiscation order, or even to shift the burden of proof to the individual to prove the source of his assets, we do believe that a person's lack of sufficient legitimate income to explain his wealth can, in combination with other evidence, establish that a person has engaged in criminal activity and that the assets in question were derived from that criminal activity. In other words, as appropriately implied, the person's unexplained wealth can be a critical factor, along with other evidence that the property is subject to forfeiture. Now, what would be an example of that? Well, the issue comes up very often in our drug cases, and in particular where a person is found in possession of a large sum of currency. For example, it's extremely common in the United States for a police officer to make a traffic stop and then find tens of thousands of dollars of cash in the vehicle. And in a typical case, a drug dog will alert to the money. The money will be found wrapped in bundles and with rubber bands, often inside vacuum sealed bags. And then the traveler tells some story that is demonstrably false or highly improbable. He says, I was on my way to California to buy real property, but he can't name an estate agent who was helping him locate property. Or I was on my way to open a restaurant, but he cannot name any person in the restaurant business that he was going to meet. Now, all of that is helpful in establishing that this person is either a drug trafficker or a courier for a drug organization. But there's one missing piece to the puzzle. And this is where the concept of unexplained wealth comes into play. Anticipating that the property owner will claim that he derived the money from some legitimate source, and knowing that the government has the burden of proof on the connection between the property and a crime, a seasoned investigator, and Jeff's point is that this requires some training and some experience, a seasoned investigator will attempt not to rely solely on the circumstantial evidence that I've already mentioned, the bundling and the dog sniff and the silly story, but will ask, where did you get the money from? And then he will seek to corroborate or to refute whatever the answer is given by looking into the person's sources of income. He will look at his bank records. He will look at his tax returns. He will look at his claim that he recently sold a ranch in Mexico or a house in Afghanistan, that he just cashed a large insurance check, that he won the lottery, and will determine whether or not that is true or it's false. And if he finds that the person lacked the sufficient legitimate income from all of his sources to explain his possession of the large quantity of currency, then that, in combination with the other circumstantial evidence, will usually be considered sufficient to establish that the money came from a criminal source, and accordingly that it is subject to confiscation. So, last point, if a person refuses to offer an explanation for his possession of the assets in question, he will at the very least have forfeited his right to rebut the government's evidence of the illicit source. And he may give the government an opening to ask a court to take an adverse inference from his silence. And there are many cases on those points in the United States. And if anyone's interested, I would be happy to direct anyone to them. But here is my bottom line. That someone has a great deal of unexplained wealth is not, in our view here, by itself, sufficient reason for the government to force him to come forward with evidence of the source of his money, or to confiscate it if he fails to do so. But that does not mean that unexplained wealth orders do not have a role to play in the process of recovering criminally derived property if there is other evidence of the person's involvement in criminal activity. His lack of a sufficient source of income to explain his possession of substantial assets may be probative evidence of wrongdoing, as well as strong evidence that the assets themselves are derived from that offense.
Thanks.
Thank
Thanks
you.
very much, Stefan. And so some food for thought. And just now we're going to move over to Maria to get some opening remarks to her. I mean, everybody in BC has been reading the recent media reports around the announcement of the implementation of unexplained wealth orders here in BC. So we're going to hear from Maria all of the great things that have happened around the world in jurisdictions where an unexplained wealth order has been introduced. And so, Maria, just a reminder to take yourself off mute, and over to you.
Thanks, Peter, and good evening, everyone. Hello from London. It's really a honor to be with those who I call, I hope they don't mind, but I call them the asset recovery gurus of Canada, the US, and Europe. So I'm very, very humble to be here. Yes, I would say that the UK experience with unexplained wealth orders, it's an interesting love story that looks like a roller coaster and is now starting to resembling more a Shakespearean tragedy in a way, despite all the things and the beginning of it. It was so much trumpeted. So I think that, first of all, when people talk about unexplained wealth orders, the UK comes to mind, obviously being London and this country, quite of an attractive destination for dirty money. It was quite necessary to talk about basically developing some mechanisms that would help the job of law enforcement authorities as relates to investigation and recovery of proceeds, not exclusively of corruption, generally speaking, financial crime and serious organized crime. However, when we talk about the UK UWOs, we need to highlight the fact that there is some confusion over the classifications of this regime, because when you look at, even very recently, there was just a publication that wasn't really sure of how to define this regime. They defined it as an illicit enrichment measure. I'm sure that Andrew is going to talk a bit more about illicit enrichment. But what happens is that they are an investigative tool that allows to do what Jeff actually was talking about, gathering information. But they are not a standalone mechanisms that leads to the essential confiscation or recovery. It leads to a subsequent civil recovery order application. And why is that? Well, I mentioned illicit enrichment. Actually, the way that unexplained wealth orders in the UK were brought forward, it was back in 2017. They were brought forward in the Criminal Finances Act, and they were the result of a very long campaign, not exclusively by civil society, but you had a lot of other types of researchers and the media, finally echoed by politicians, about the need to have a tool that would tackle some of the challenges of recovering the proceeds of grand corruption, cross-border corruption, and kleptocracy, if you want to call it this way. And also serious organized crime. These orders, these UWOs in the UK, they're also known as Mech Mafia. order. I don't know if anybody has watched the BBC. It is a TV series. It ran for quite a few seasons, but it's also based on a book that is called McMafia. And obviously it was highlighting not exclusively the role, obviously, of London in this whole mess, but generally speaking, how serious organized crime and kleptocrats, they are somehow one of the same. They do use very similar tactics, and they exploit major vulnerabilities in our financial defenses. So they were very much trumpeted and brought forward with a lot of, they made a lot of noise because they were advertised as the solution to all our problems. Essentially, finally, we have a way to gather that information that, as both Steph and Jeff actually said, that evidence is often in an uncooperative, if not hostile, if we talk about, for instance, Russia, jurisdiction. So how do you get that evidence? Well, you reverse the burden of proof and you actually have the subject of this UWO to present it. If only was that simple. Actually, it's not how it is. So the common misconception about the UK UWOs is that the UWO requires the person on whom it is served, so the respondent, to prove the legitimate origins of their assets or face their confiscation. However, this is just sometimes the case, and I explain why. So the process is it's not very simple, actually. It's a four-step process. First of all, the enforcement authority makes an application for the UWO. Then the court decides whether or not issuing this UWO is specific requirements are satisfied. So first of all, there must be reasonable cause to believe that the respondent has an interest in relevant property that is worth more than £50,000. Then there are reasonable grounds for suspecting that the respondent's legal sources of income at the time of making the application would have been insufficient to obtain the property. I think, well, if you usually check and look for unexplained wealth order, a very famous case is the first UWO was brought forward because there was this lady who had spent, I think, more than £1 million on sandwiches at Harrods, at the time not having a job whatsoever. So that, that was quite indicative of something that was not really as it seemed. So this is the second requirement. And then finally, the final requirement is that the respondent has to be either a politically exposed person or there are reasonable grounds, again, for suspecting that this individual or a person connected to them has been involved in serious organized crime. In the UK, serious organized crime also includes money laundering, by the way. So if all these circumstances are met, then the court decides to grant the order. And once issued, the UWO compels the disclosure of certain information about how the respondent could afford the property. They need to provide a statement about the nature and extent of their interest in such property. And as I said, the means with which this property was obtained. And now this comes the final, and which is actually the most crucial part of the UWO. So it's all a matter of whether the respondent decides to comply and provides a statement or does not comply. So in case of compliance, then the enforcement authorities must decide. I think that they have extended now with a recent amendment, but it had at the time up to 60 days to decide whether or not they would commence a separate civil proceeding or recovery order, in which they have to essentially satisfy, like the court must be satisfied on the balance of probabilities that the property in question is connected to unlawful conduct. So obviously they have all this information that has been provided by the respondent of the UWO. It is not clear whether they need to actually go further than that and say, no, we actually need to provide even more, given that there is a civil standard. That's in case of compliance. In case of non-compliance, then the enforcement authority commences basically straight away a separate civil proceeding or recovery order over the fact that essentially the respondent did not comply. So, as I said, it's quite interesting because it's not about whether there is a connection between the property and unlawful conduct, but in this case, it's a matter of non-compliance in itself. And in both cases, whether it is compliance or non-compliance, the respondent has additional opportunities, time and time again, to satisfy the court that on the balance of probability, the property has not been purchased unlawfully, essentially. So, in a nutshell, it's a complicated mechanism. It's a two-step process or four-step process, if you want to say it in this way. And this has confused everybody in the sense that I was talking even recently with some MPs who have pushed for some even amendments to this UWO regime. And they were just, as it relates to the matter of the oligarchs, they were saying, we have the UWOs. Why don't you just grab the assets? They're there. And I said, that doesn't work that way, and they were very confused about, so is this just an investigative tool? Yes, it is. It's very good to obtain that information, but that's where the buck stops. So has it worked? As I said, not really. The original idea, what they had in mind was to have at least 20 unexplained wealth orders per year. So far, we have had 15 unexplained wealth orders, but relating only to 4 cases. Of these cases, 2 cases concern the PEPs, and only one has been successful essentially. And that was actually the only one with serious organized crime with an individual. So to wrap up, why has this happened? Well, again, the difficulties in overcoming information legislative gaps are still there. What Jeff and Steph have already highlighted, which is the matter that we do not have experienced law enforcement officers. It's very difficult to trace the assets, to provide that evidence, and to, generally speaking, understanding the environment in which foreign corruption most of the times work. The times that it has worked, it has been because the respondent has potentially provided too much of an information. So I'm sure that Jeff is going to talk about this issue of self-incrimination. But generally speaking, I think that UWOs have a great potential. We can talk about some additional challenges that they have. But so far, they have been not used and they have resulted in very high costs for law enforcement, reduced the appetite. And it's a bit of a failed story. Sorry to bring the negativity.
Thanks very much, Maria. And I very much appreciate that sort of view of the UK. And there are some lessons learned, obviously, for us to take away from that in Canada as well. Andrew, I think it'd be good to hear from you to get the context of the effectiveness of a UWO, where it's used, how it's used, and sort of what the end results of that are, in terms of just sort of setting the landscape from your opening remarks on this topic.
Yeah, thanks, Peter, and thanks for having me. Good evening to everyone from Switzerland. So I know I've only got a short amount of time, but what I wanted to talk about mainly in my opening comments was what unexplained wealth actually is and what unexplained wealth laws actually are. Maria mentioned in her comments that there's quite a lot of confusion surrounding these concepts. And the reason for this is that a lot of terminology actually gets thrown around that either talks about the same things or talks about different things. And so I'm going to take my 10 minutes to just strip everything back before we get into the discussion and outline exactly what we're talking about when we're talking about an unexplained wealth law and what we're talking about when we're talking about the concept of unexplained wealth, particularly from an international perspective. Hope that will provide maybe a little bit of a frame for the discussion that we're going to have going forward. And I think it'll also provide maybe a little bit of perspective on the type of law that the Cullen Commission actually recommended gets introduced into British Columbia and what the potential implications of that might be. All right, so let's start from ground zero. What are we actually talking about when we're talking about unexplained wealth, or what are we talking about when we're talking about someone enjoying unexplained wealth? So from like the absolute broadest sense, taking a step back and looking at all the laws that cover this, the enjoyment of unexplained wealth refers to the acquisition, the receipt, or the use of something of a pecuniary value by a person that has not or cannot be justified by reference to lawful income. Okay. And this phrase, unexplained wealth, and this concept of unexplained wealth, like I said, it often sparks a lot of confusion. What do people talk about when they're talking about unexplained wealth? And the reason for this is because everyone uses different terminology, depending on where you're from, to talk about unexplained wealth. And so while I'm talking about the enjoyment of unexplained wealth, there's a lot of countries around the world and even a lot of international instruments such as UNCAC, which actually refer to the same concept as illicit enrichment. It's a very common way to refer to this concept too. Other countries, again, refer to things like unjust enrichment, which adds a little bit more confusion because there's a civil concept called unjust enrichment as well. Other countries, again, refer to illegal enrichment, and I'm pretty sure there's one country that refers to it as something like the liability of corrupt acquisitions or something like this. So, everyone's got different terminology when they're talking about the exact same thing. So understandably, there's a lot of confusion when you're trying to figure out what someone actually means when they're talking about unexplained wealth or illicit enrichment and all these sorts of things. So that's what unexplained wealth is. It's basically, it's illicit enrichment. It's the enjoyment of unexplained wealth. It's the enjoyment of something of pecuniary value that has not or cannot be explained by reference to lawful income. But what is an unexplained wealth law? So Maria mentioned this as well. A lot of confusion when people are talking about unexplained wealth laws, what they can do, what they can't do. The media is always sort of going up in uproar and there's always headlines like this country here is introducing an unexplained wealth law and going after kleptocrats or going after anyone. And like I said already 100 times, there's a lot of confusion about what this actually means. When you're talking about an unexplained wealth law, this could refer to many mechanisms. And these mechanisms all have very different powers, are based in different procedures, and can potentially have very different implications on things such as legal rights. So it's quite important to take the time and actually explain what different types of mechanisms actually exist when you're talking about unexplained wealth. And that's what I'm going to do briefly now while I've got a few minutes left. I'm going to talk about sort of the four major categories of unexplained wealth laws that are referred to. I'm going to talk about criminal unexplained wealth laws. I'm going to talk about civil unexplained wealth laws. I'm going to talk about a category of law that doesn't really have an official name, but which I call qualified unexplained wealth laws. And then finally, I'm going to talk about the category of unexplained wealth law created by the UK, which is confusingly quite a different type of law, as Maria has mentioned. And I'll explain how all of these are sort of similar or different and how we can set them apart. Okay, so first of all, what's a criminal unexplained wealth law? Or often these are actually called illicit enrichment offences as well. So what is this type of law? Well, it's a legal mechanism under which it's an offence to enjoy wealth that cannot be justified by reference to lawful income. So under a criminal unexplained wealth law, if a person, or sometimes specifically if a public official, enjoys wealth that is proven, usually beyond reasonable doubt, that is disproportionate to their lawful income, and then this person is unable to justify this disproportion to the court, then that person basically commits a criminal offence, and they can be sanctioned with a criminal punishment. They can go to jail, they can be fined, and usually there's some sort of criminal confiscation procedure as well that goes after the actual unexplained wealth that's been identified in the process. These are actually the most common type of unexplained wealth laws that exist around the world. They're even recommended by international legal instruments. UNCAC recommends that countries adopt these types of laws. Also, the regional anti-corruption instruments that exist in the Americas and also Africa recommend that these types of laws are adopted as well. They honestly exist all over the world. They exist in pretty much all continents around the world. They exist in places like Mexico and the Americas, Argentina, South America, Hong Kong and India and Asia. They exist in Europe in places like Lithuania and Moldova, and they exist honestly throughout Africa as well. They're not just limited to common law systems or civil law systems. They exist in all systems of law. So that's criminal unexplained wealth laws. Civil unexplained wealth laws are a bit different. These laws don't exist as a criminal offence. These laws exist as a civil procedure process where the state can launch a civil action against a person that they believe has unexplained wealth. Okay, and under these mechanisms, if a civil court finds that a person has enjoyed an amount of wealth that has not been justified with reference to their lawful income, then the court will make a civil order that generally forces the person to pay to the state the value of the wealth that is deemed to be unexplained. Okay, These laws really aren't as common as criminal illicit enrichment laws or criminal unexplained wealth laws, but they do exist in a number of countries around the world. They exist quite predominantly in Australia, for example. They also exist in places like Fiji and Mauritius. Important to note, there's one similarity that really binds these two examples together, and it's one key element of these types of laws that really separate it from, say, the laws that Jeffrey was mentioning or Steph was mentioning in the US. And this element is that basically under both these types of laws, the court doesn't need to see any proof whatsoever that a criminal activity has taken place before they'll impose a sanction on a person. And this element is obviously the most controversial element of these types of laws, which I'm sure we'll discuss throughout the next hour as well. So that's criminal and civil unexplained wealth laws. And that brings me to the third category of laws, which is quite easy to explain, actually. And these are the category of laws I call qualified unexplained wealth laws. And these laws are basically the same as criminal and civil unexplained wealth laws, except for one fact. And that is that these laws do require the state to prove something small relating to criminality. They don't require the state to prove that a crime has taken place to any standard, not even to the standard of a non-conviction based forfeiture law. What they require is the state to prove that there is a reasonable suspicion or a reasonable belief that some sort of criminal activity has taken place. So let me be clear on that. They don't require the state to prove any criminality has taken place. They just require the state to be able to justify a reasonable suspicion or a reasonable belief that crime has taken place. I note that my time is running out, so I'm just going to be really quick and mention the final category of laws, which is basically the star of the show today. So quite confusingly, the UK introduced the law that Maria has already talked about quite comprehensively, which is called the Unexplained Wealth Order. The reason I say that this was quite confusing is because even though they call this thing an Unexplained Wealth Order and use the exact same terminology as all the other laws I've already mentioned, this law operates very, very differently. So it's very important that when we're having a discussion about these types of laws, we differentiate the implications that maybe a UWO might have on a person, what obligations these types of laws actually put onto a person, compared to, say, more standard unexplained wealth laws, more standard civil unexplained wealth mechanisms that I've already talked about, or even the criminal mechanisms that I've talked about as well, okay? Like Maria said, I'm not going to hash onto this too much, but the UK mechanism differs on one key thing, and that is that it's an information gathering order. It doesn't allow a court to impose a sanction onto a person that will result, say, in the confiscation of their unexplained assets. It just puts an obligation on a person to provide some sort of information, usually relating to the sources of their assets, of course. If they don't provide that information, it doesn't necessarily mean that these assets are going to be confiscated. There's extra steps that Maria has already explained, which need to also happen before the confiscation can actually take place. Okay, so I know I've run out of time, so I think I'll stop it there. I hope that maybe gave a little bit of context to everyone on how to differentiate between these types of laws. And as a final note, I'd like to mention that obviously the Cullen Commission, if you actually read the report, it recommends this final type of law, which is the UK UWO, to be introduced. And there's obviously some opinions on whether or not that is the correct model to introduce, but I'm sure we'll discuss that going forward a little bit. And that's where I'm going to leave things for the moment. Thank you very much.
Thank you. Thank you very much for that, Andrew. And it's an excellent segue into sort of our first area to dive into with the panel. And so we all understand that BC has now introduced, or is planning to introduce, it hasn't introduced, but is planning to introduce legislation around the creation of an unexplained wealth order regime here in the province. It's also a unique situation here in BC in that the former executive director of the BC Civil Liberties Association, who is now our premier, is behind the introduction of this legislation. And if you read the Globe and Mail this morning, you'll see that the BC Civil Liberties Association is also already quite critical of the suggestion of the introduction of that legislation. So one of the first things I'd like to come back to you, Jeff, with is around the regime here in British Columbia We've had a great discussion around, started with BC and Canada, but now we've had a great international discussion. But BC already has a civil forfeiture office. So one of the things many people might be asking themselves, if we have a civil forfeiture office and regime here in BC, what value does the unexplained wealth order add to that?
Right. So, just a couple of things, maybe just to track back to some of the things that the speakers spoke about too. We're going to close this session, I think, with the chair from Transparency International Canada. In the UK, Transparency International was one of, Maria talked about civil society. They really advocated prior to 2017 to bring this to the fore. But just to close back, so what Cullen found was that the entire system wasn't working from a law enforcement perspective. And so it starts with the police, and he makes recommendations that any investigation by a police force that includes any kind of unlawful activity for profit, whether that's drugs, fraud, kleptocracy, whatever it is, that it should include a proceeds of crime investigation. That is just not happening right now in BC, and Cullen found that it needs to. And the logical first place for those charges to go will be to the hands of a prosecutor. We have a pretty robust system under the Criminal Code, the Controlled Drugs and Substances Act, that will allow for forfeiture of assets following a conviction. And I've trained thousands of police officers across Canada and the United States on civil forfeiture. And I always tell them, if you can go through a conviction-based process, do, because it actually helps the prosecutor to show the table full of money when they're trying to prove the substantive offense, whether it's drug dealing or whatever. Civil forfeiture only comes in where that doesn't work. And I think later maybe we'll get to tax, because I think that's another avenue that's there. And I think what Cullen said was, we're not doing enough civil forfeiture. It's not commensurate with the risk that money laundering is posing to the province. And this is kind of interesting to me anyway. So BC, the civil forfeiture officers does about $13 million a year in forfeitures. And the comparator that the commission found really helpful was New Zealand, which I found that kind of surprising in terms of population and GDP. BC and New Zealand were really considered comparable. Over a 3-year period, instead of $13 million, New Zealand forfeited $358 million. So significantly a larger sum. And then so that we're not our usual smug central Canadian selves, Ontario is about $2.2 million last year, and that doesn't account for a badly argued $3.7 million case that they lost and had to return the money. So the idea of the UWO, I think Cullen really considered, can we add presumptions? Can we add different categories for civil forfeiture? But I think at the end of the day, he found, and people like Steph and I told him, the law is pretty good. The litigators are good. You probably need to add some capacity and some breadth into that unit, but you really need to start at the beginning with those investigators. And a UWO at the other end, at the output end, will help you with what I talked about earlier, that informational asymmetry.
Thanks very much for that, Jeff. And Maria, just expanding on that question, around what type of UWO. Andrew had raised that the Cullen report had recommended a UK-style UWO. You've talked about the UK-style UWO. What's working, what's not? What would you recommend? If we're going to follow the UK model, are there any tweaks that we need to put in place?
So first of all, I think that the UK model, it's not completely to throw away. Obviously, one of the good things that we had in March was a series of amendments to the UWO regime. I did not go too much into details, but because following Russia's invasion of Ukraine, some legislation targeting economic crime, it was fast-tracked. Basically to show, a bit of a response to what was happening and to the fact that for a long time we had accepted some money coming into this country. So among these amendments were aimed at least at revamping a bit more the UWOs that so far only four cases have been brought forward, mainly because of a series of challenges. One of the challenges was the fact that it was very, very expensive for law enforcement to actually pursue a case because of the costs they would incur should this UWO be unsuccessful. So one of the amendments that they included was, for instance, the cost capping for law enforcement agencies as it relates to UWOs, which is great because the idea is if there is cost capping, then the appetite of law enforcement should potentially increase. Then the second amendment also relates, well, aimed at tackling another challenge that was quite important, which is the fact that most of the times, if I am a kleptocrat, I'm not, but still, if I were a kleptocrat, I would not own property in my own name. Most of the times it's behind trust. It's very difficult to trace that specific, property back to their individuals. So the way that these amendments did was essentially expanding the target of a UWO so as to include, for instance, trusts and nominees. And then finally, it also extended the time for law enforcement to respond to a UWO. However, what happens in the UK, and I think that this is actually a very important lesson for BC and generally speaking for any country that wants to introduce and follow the UK model, is it needs to be properly resourced. So far, we cannot really see and we cannot really say if UWOs, even with the amendments, are going to be successful because simply there has not been a single case brought forward. We know one, but we actually don't really know. We don't really have public information on this matter. So I think that definitely we need some more resourcing from law enforcement agencies. There are obviously other issues for the UWO, the way that the UK has decided to do it. I do not necessarily agree with what I was saying, that it is just a compliance mechanism. It's not unexplained wealth, as Andrew has explained. I think that those ones potentially can be a bit more successful, but definitely, as long as we don't try them, we will never know if these amendments have been successful. And I'm also conscious that when we talk about those who can seek a UWO, obviously people think of the National Crime Agency in the UK. However, the NCA is not the only body authority that can seek UWO. We have, for instance, the Serious Fraud Office, HMRC. I saw in the questions that actually they were asking about the role of revenue agencies. HMRC in the UK could seek an unexplained wealth order itself. So there is a role for everybody to play. What happens in the UK, and it's something similar to what Jeff mentioned for Canada potentially, is the framework is very siloed and there are lots of different agencies and not always cooperating and communicating with each other. So yes, HMRC could play a role, revenue does play a role sometimes. Generally speaking, for us to recovery, the NCA has taxation powers under Section 6 of the Proceeds of Crime Act, but these are underutilized. For instance, so far, only 15 UWOs have been brought forward. None of them was brought forward by any other authorities aside from the NCA.
Thanks for that, Maria. Now, Stefan, in terms of Maria brought up the HMRC, sort of the tax revenue agency in the UK. Has the IRS played a role in asset forfeiture in the US?
Yes, they have, but it's important to understand that the tax people within the IRS are entirely separate from the anti-money laundering people within the IRS. So the IRS has a criminal investigative division which assists in and sometimes is the lead on money laundering cases involving complex financial transactions going through domestic and international financial institutions. And they do that because they have that expertise and they're very good investigators, but that is not part of the revenue collection function. It's very difficult, as a matter of fact, not only for another law enforcement agent, whether it be a policeman in a local jurisdiction or an FBI or a DEA agent, to get tax records from the IRS. And there's also a wall between the IRS criminal investigators and the IRS tax people. So tax investigations are generally not part of this process.
Thanks for that, Stefan. And Andrew, just to round this out, so again, we've had the comments from Jeff and from Maria in terms of the UK UWOs, but what sort of, you mentioned that it needed to follow the UK model. what sort of adaptations might be necessary to the UK model from your perspective to make it work in another jurisdiction such as Canada?
To be honest, there's quite a few that you could mention. I'm gonna caveat my response first by saying I think Maria made an important point here. A lot of people really shovel a lot of negativity on the UK UWO. There's a lot of people say that was spectacularly unsuccessful. A lot of criticism that exists out there, and you know, I personally am not a massive fan of the UK UWO myself, but I would like to caveat by saying that this law just hasn't really been tested. So when I criticize it now and say that there are a few adaptations that should take place to really increase the chance that this law is going to be successful in British Columbia, I'm saying that knowing that the UK UWO hasn't really been tested. So we're not quite sure of what its potential can really be. I think there's quite a few ways that the UK UWO is going to have to be adapted already for it to be sort of lifted up and put into British Columbia. The UK UWO is sort of one that's applied by a law enforcement agency, the NCA, which has a very wide reach throughout the UK and actually has a big international network as well. And due to the particular circumstantial elements that exist in Canada, I'm not sure that's going to be quite possible. So you have to think that they're going to have to adapt the law, obviously, to be applied by the Civil Forfeiture Office in the UK, which is already going to be quite different to what happens in the UK. Also, it's quite important to note that the UK UWO applies UK-wide. In Canada, and as Maria already mentioned, it's quite siloed. And if they were going to actually transport this mechanism and drop it in British Columbia, they'd have to adapt in a way that obviously it can't be applied throughout Canada because that just wouldn't be allowed. There are individual jurisdictions that deal with the civil forfeiture side of things in Canada, so they are going to have to adapt it for that too. In terms of improvements, I think there's quite a few that you can mention, but I won't go on too long. To be honest, I think the UK amendments that happened earlier this year did some good things, but some of them didn't go far enough. For instance, if someone does reply to a UK order, there is still a time limit under the UK mechanism within which the state has to decide whether or not they're going to pursue the case. And for me, that's one of the fundamental flaws of the UK model. I think, honestly, the time limit at the moment was expanded even to about 186 days. But if you're dealing with a complex financial case that includes evidence from a lot of international sources, some of which, you know, there'll be jurisdictions that really don't want to cooperate with you. So 186 days in the context of mutual legal assistance is not really a lot of time. And I think you're hamstringing a lot of efforts to seek UWOs by including that time limit. And I think if they do drop this law into British Columbia, they should look at that particular limitation and hopefully get rid of it completely, or at least expand it drastically. In terms of other wider improvements, to be honest, as I mentioned before, I'm not the biggest fan of the UK UWO. I do think that it's extremely limited in that it only requires a person to provide information. It doesn't actually require a person to provide truthful information, for instance, or it doesn't require a person to provide information that can be easily verified. Therefore, I think it's quite easy for people to get around the UWO if they really want to, especially if they've got international connections or people that can produce documents that will require MLA to verify them, you know. And I think from that point, you know, I know that this raises big issues and it really sort of would spark many debates everywhere. I think you really need to include or introduce a mechanism that does put some sort of burden onto a person to prove the lawful sources of their wealth. And I know that, you know, you have to take into account rights issues in certain jurisdictions and what the particular context is. But if that type of mechanism can be introduced, from my perspective and my experience when looking at these types of cases, that's what's really going to increase the chances that a mechanism like this is actually going to be effective. It's going to identify unexplained wealth, and it's going to eventually lead to the confiscation of this unexplained wealth.
Thanks, Andrew. And I just want to stay on this topic a little bit longer, and I want to get a Canadian response too. So we've heard from, the UK tax people, the US. So Jeff, but I want to roll in sort of what is the role, not just of, say, the CRA in terms of unexplained wealth orders in Canada, or what would it be, or how could it work? Because I know that the CRA is notoriously secretive in terms about sharing taxpayer information with other government entities, but also what about FINTRAC? What role would FINTRAC have? Because we know that in the Cullen report, FINTRAC was sort of sent to bed without its supper. So what role would they have as well?
Okay, so a couple quick things. Start just quickly with the UK, and just so people have a sense of why it's been criticized. Some of the assets, and this is in the context of kleptocracy. Someone that brings an asset into our country that they've stolen from Treasury in another place are probably going to be very well advised, and they are going to create a cover story or a legend for that asset. And the Russian oligarchs are the best at this, and they're the best because they don't just have to worry about people like Steph and I and so on. They've got to worry about Putin, because as we've seen with Kordosky, when someone falls afoul of Putin, then you have the Russian state kind of going after you. So they really work hard to hide things. And so the UWO that didn't succeed, there's a story with an oil field and a divorce settlement, or there'll be a beet farm in Kazakhstan or something. There will be some way of explaining that asset that it will never be in the power of the Civil Forfeiture Office in BC to disprove. So that's kind of the challenge there. On taxes, the Canadian Revenue Agency, they don't really care where you make your money. They really don't. They're going to tax whatever they can tax, but they are constrained both statutorily and under a jurisprudence. So there was a case several years ago, Jarvis and Ling, and it says that, if a CRA person is in there as a tax auditor, they can only go so far with what they have, and they have to stop. And if they want it to, for example, tax evasion, as Steph mentioned, that's a crime in Canada too. Money laundering is a crime. Money laundering the proceeds of tax evasion is a crime in this country. But once the auditor reaches the auditor can come in, they can look at your business records, they can ask you questions. But once they think, oh boy, I think I'm going to charge someone with criminal tax evasion, they have to stop. They have to put their pen down, and they have to hand the file over to another part so that it moves from verification over to the investigative division of CRA, of the Canadian Revenue Agency. And I will say too, to Steph's point, they do not like to share information with anyone. And on the civil forfeiture side, you can do an application under the Criminal Code of the Controlled Drugs and Substances Act, but that information would be unlawfully in the hands of the civil forfeiture director if he had it. He's not allowed to have it. So those barriers, those silos, they exist there as well. The FINTRAC question is really quite an interesting one, and it may be just to scope out just slightly to go more 30,000 feet. We have an anti-money laundering system all through the West. We've had it for some time. It's constantly being reviewed and checked. There's a group, the Financial Action Task Force, that evaluates, does mutual evaluation reports on countries. Canada's been evaluated, the United Kingdom has been evaluated, and it's by no means a perfect system. It really, really isn't. But it does a couple of different things, and I just want to focus, because Cullen looked at this as well. So there are barriers that system creates. For example, with financial institutions, if I walk in there with more than $10,000, they have to report that information. If I'm their customer, they need to know what my business is. And if I have something that's suspicious, they need to look into it. And because they know me as a customer, they may need to conduct extra due diligence. Those barriers aren't perfect, but they're good in the sense that they keep some of the low-lying fruit out of our system. In fact, one of the problems that Cullen talks about is bulk cash smuggling. That means literally taking one of those great big metal containers that goes on the ship, filling it with cash, and sending it to a place like Mexico or Central America, where the controls are less rigorously enforced than they are here in Canada. So there is that role, and FINTRAC has a role as a regulator. So they oversee, in fact, OSFI, the Office of Superintendent of Financial Institutions, has now sort of exited the field, which I don't think is a good thing, but FINTRAC now looks at how those financial institutions are dealing with that system, how they're managing as a regulated entity. The failure of FINTRAC has been that they really are a poor conveyancer of information. That's really what their role should be. So they receive millions and millions of reports. They only produce 2,000 or 3,000 disclosures to law enforcement, and most of those are ones that law enforcement has asked for. So there's very, very few that they are producing genuine, actionable intelligence. I was on a national panel a couple of days ago with a person from Finance Canada, and they assured me that they're significantly increasing the resources to FINTRAC, and they're very aware of the issues that Cullen identified, and they're working hard at fixing them, which is something that I take some heart in.
Thanks very much for that, Jeff. And I just want to jump ahead a little bit. And one of the things that, of course, dealing with unexplained wealth orders that has been raised on the call so far is that reverse burden of proof. Now it is incumbent upon the defendant or the accused to demonstrate that their source of wealth is legitimate in the eyes of the law. And so from that standpoint, it would be, as we're sort of exploring this evolution in Canada, Stefan, the U.S. has been not with unexplained wealth orders, but has this reverse burden of proof around in its jurisdiction. And how would the U.S. around asset forfeitures? How does the U.S. deal with this?
Well, we no longer have a reverse burden of proof. That was very much the law in the United States for the first 200 years of our civil forfeiture experience, beginning in the late 18th century and up until the year 2000. The onus was on the property owner to demonstrate the legitimate source of his property once the government established that there was reasonable cause to believe it might not be legitimate. People were accepting of that process when we were talking about pirate ships and slave traffickers and smuggled goods, but when we were talking about people's houses and cars and bank accounts and businesses, they thought the onus should be on the government. And so the law was changed 22 years ago, and the government now has the burden of proof in all instances. The effect of the ability to force the person to come forward and explain his wealth is to leave the government's evidence unrebutted if he doesn't do that. So the government has to have evidence of criminal activity. I gave an example earlier about a pile of cash and wrapped in rubber bands and a dog sniff and all of that. And if the person doesn't come forward with an explanation for his wealth, that remains unrebutted. And we do have the ability to take an adverse inference, that is, ask the court to take an adverse inference from the invocation of the right against self-incrimination. You can take that, you can invoke that right in a civil forfeiture case and refuse to answer a question about the source of your money, but the court can take an adverse inference of that. And that would add there, and that inference would therefore add to the quantum of evidence that the government has put forward, circumstantial and otherwise. But nevertheless, the government is at all times going to maintain the burden to establish that a crime was committed and that this property is connected to a crime.
Thanks for setting me straight on that, Stefan. And maybe, Jeff, what we'll do is we'll come to you, just sort of set the perspective of what Cullen was recommending around this issue in terms of grappling with that burden of proof issue. And then, Maria, it would be really good to hear from the UK's perspective.
Yeah, and I think Andrew's perspective maybe on Australia and Ireland might be helpful too, Peter. So what Cullen had heard from Maria's colleagues at Ritchie, and I don't want to be unfair to them, but they sort of like, really? You want to do the UK model? He certainly knew they were far more British and far more polite than that, but he certainly had heard about some of the issues, and he had heard from the director of Manitoba as well about how their system works. But here's what he recommended. He said that a UWO would be a court order that could be obtained by the director prior to bringing a civil forfeiture proceeding, which actually is fairly important because you need to have jurisdiction to be before a judge and in the court. That would give it to you. And that order would disclose the nature, extent of origin of the ownership, the source of the funds, whether there's a trust or a nominee relationship, and anything else that the court saw fit to order. And the consequence of not complying with the order was it would give rise to a rebuttable presumption that could be used later. Cullen recommended that if false or misleading information was provided, that there should be very serious consequences, like the person should be prosecuted types of consequences. The standard he called for was reasonable suspicion. And the question would be for Cullen, was the respondent or potential respondent involved in unlawful activity in the prior 10 years? One of the features of the UK system and the Australian system and the Manitoba system is that you had to actually show that the assets that the respondent held were disproportionate to what their known lawful income was. And actually determining known lawful income is a really, really complicated, messy thing. You need forensic accounting and so on. The two other things just to mention very briefly in passing, Cullen recommended a $75,000 minimum as a safeguard to make sure it's not used for small cases. In Manitoba, by the way, it's $100,000. And then he also recommended there be some thought given to a limitation period.
Thanks for that, Jeff. Maria, how is the UK looking at this?
Well, the UK is not necessarily looking at reversing the burden of proof fully. I think that the conversation has started, just as I said, right after Russia's invaded Ukraine. That's when some policymakers realized that potentially we need to be a bit bolder to face the challenges that are presented by dealing with proceeds of grand corruption and kleptocracy. Really don't like the term kleptocracy, but you know what I mean. I think that generally speaking, the UWO as it is in the UK was also the result of some reticence by some, what Steph mentioned, because fully reverse the burden of proof raises concerns over potential presumption of innocence, right to self-discrimination. So the way that it was done in the UK was also, to prevent potential human rights abuses. However, we have jurisdictions, and I'm sure that Andrew can talk a bit more about that, but we have jurisdictions that do have full reverse burden of proof. These have been challenged in courts, presented of the European Court of Human Rights, and they've all won. Essentially, that they've never been a case where it says, yes, it's actually violating this presumption of innocence. So whenever we talk, especially with some officers of the NCA, actually, whenever I ask this question saying, what would make your job easier? They say bring full reverse burden of proof, like they do in, for instance, Ireland, or like they do it in Australia. I will let Andrew actually talk more about those cases because I think he has written extensively on those. But yes, it is something that especially law enforcement authorities really want in the UK.
Thanks for that, Maria. Andrew.
Yeah, thanks, Peter. So I know this issue is controversial. From the outset, I do want to say that, but I at least wanted to maybe explain the argument for introducing a mechanism that has a reverse burden of proof in the context of unexplained wealth, at least, and specifically in the context of a civil unexplained wealth law. I won't go into the criminal side of things. I think that opens up even more doors that can be explored, but at least, I did want to explain maybe an argument for introducing a burden of proof in a civil unexplained wealth law. And as it's been mentioned, this has happened before. This does exist in other developed jurisdictions as well, including many jurisdictions within Australia. And it's quite interesting. There are these mechanisms in Australia with these laws where there's a bit of parliamentary oversight for these laws, and every now and then there'll be a committee that launches inquiry that looks into the effectiveness of unexplained wealth laws and examines, are they fair? Are they being abused? All these sorts of questions. And in one of these Senate committee reports that dealt with, I think, the federal jurisdictions laws, this committee was asking the question to a lot of people. It was saying, well, is there realistically a circumstance in which a person would not be able to prove the lawful source of their wealth if the wealth had come from a lawful source? And the answers to this was no, not really. The only exception that one person could literally come up with would be if there was, say, an immigrant or even a refugee from a country that had to flee quite quickly their home country. They liquidated their assets, they came to the new country, and then they bought a bunch of things, okay? They wouldn't be able to produce evidence that showed where the source of their wealth has actually come from. And that might be one of the exceptions to this entire thing. But generally, if you're talking about your normal citizen, you're talking about me, I can explain where all my wealth, my limited wealth, has come from. And I think for law-abiding citizens, that's exactly what the case is. So when you're talking about reversing the burden of proof and asking someone to explain the sources of their wealth, you're not really doing something that is too controversial. Of course, it's better if the state has the onus to prove absolutely everything in all circumstances. But the thing is, there are some situations where it's better for the person to be able to prove certain things. And when they actually looked at this issue in one Australian case, the judge did ask, is it reasonable to reverse the burden of proof in this situation? And the judge was like, well, no, it is reasonable. We're not asking the person to do anything outrageous here. We're asking them to provide information that is specifically within their own knowledge. And it's specifically information that they should easily be able to provide. On top of that, if the onus to actually prove the sources of this particular wealth was on the state, this would require an incredible amount of resources on the state to go through and find the sources for every single asset. And that just wouldn't be reasonable. And especially in the civil context, where there is often the idea that a person who is in a better position to prove a fact should be proven that fact. The idea of reversing the burden onto someone to prove the lawful source of their wealth, it doesn't really seem that outrageous. And I think that's why, when you introduce these sorts of mechanisms, it is a question that should be discussed quite seriously, is whether or not you should actually introduce an exception and put a reverse burden onto someone to explain something that they really should be able to explain.
Thanks very much for that, Andrew. And Jeff, sort of from just staying on this topic at first, in terms of maybe quickly addressing how the legislation in Canada, the Criminal Code of Canada, addresses this topic, but also then maybe a broader question to you around the enabling legislation that needs to be in place. What needs to be sort of taken into account as jurisdictions start to sort of discuss the implementation of unexplained wealth order legislation?
Sure. So, one of the questions in the panel, it's a very good question, is, does the criminal organization offense under the Canadian Criminal Code cover this? And it's an interesting question. And the answer is sort of yes and no. And by that, what I mean is, I don't think anyone who's genuine about what they do in the civil forfeiture space wants to oust the role of police and prosecutors. Like, there are people where it's frankly not enough to get their money. We need them in jail. We really, really need them in jail. And the only way to do that is to follow the criminal justice system through an investigation and in the hands of prosecutors. And we do have good tools. A criminal organization offense is a great example. It's not the only one. There's several others. And it opens up a lot of different law enforcement techniques, from wiretaps on to whatever, warrants and all that kind of stuff. So that process is there. And I think Cullen he has a whole chapter on criminal asset forfeiture, and he says there needs to be more of it. Then we need to improve things. We need to build the infrastructure to make this happen. Remember, he started with the notion that there was at least 10 years where the RCMP just simply vacated the field and were completely inattentive. So that's the first thing I just wanted to say. Cullen does say on UWOs more generally that the person in the best position to explain the source of their wealth is the person that the order would be applied to, and it shouldn't be a great burden. It's interesting, Manitoba's director came and she testified to the commission. She was asked about, and I hope I'm not being unfair in how I characterize her remarks, but she asked about how this might work. And she said, well, take the example of a biker. So we have outlaw motorcycle gangs, and they're often very involved in criminal activity in Canada. There have been some real pitched battles between the Civil Forfeiture Office and the Hells Angels in BC. I had many of my own battles with the Hells Angels here in Ontario. So she said, if a biker has died, so he's passed away, he's a motorcycle accident or whatever it is, there is not ever going to be a criminal investigation. There's no one to charge, there's no one to investigate, but that person may have left behind a legacy of $1 million of assets, clubhouses, farms, whatever. She said, there's a good example where you might actually use a UWO, and Americans have slightly different things for fugitives and dead people and stuff than we do, and Steph maybe can speak to those. But there was kind of an example of that. But the real key to this all working, I think Andrew's right. I think there's lots of ways you can tweak the legislation. For example, in New Zealand, it's slightly different. It's a disclosure of source order. And if you don't comply with it within, I think it's 4 months, you lose, if your asset is forfeited. It's not about a rebuttable presumption. And that's because they have a lot of offshore people, including oligarchs who have assets there. They won't want to come in and return to the jurisdiction, so they might walk away. And they think they'll make about $25 million a year just on that provision in New Zealand. But the real key to all of this, and this is my closing point, is the infrastructure around this. That if you don't have investigators at the civil forfeiture director takes the case as it comes to, in BC right now, it's a him, as it comes to him. He doesn't investigate, and there, I know Manitoba's looking at sort of building up some capacity so that they can improve what they have once they get the case, and I suspect BC is too. But that's that getting the police in place, getting those specialized units. It takes 3 to 5 years to train an officer so that they're good enough to deal with someone like Steph, for example, on that simple money stop, because they learn all these different things about how money is bundled and banks use it and all that kind of stuff. So that's, I think, the biggest key for success is if you just pass a UWO and you don't resource law enforcement, it will fail, and it will fail spectacularly.
Okay, thanks for that, Jeff. Maria, same topic, but from the UK perspective.
Yeah, I actually think that what Jeff said, this last words where I was just like nodding very openly. I think that it's quite easy, to just rely on legislation, but unless laws are properly enforced, there's just going to be a nice piece of paper. And in the UK, what we have and what we often say is the fact that laws are often very good. I mean, it's not necessary to reinvent the wheel. Most of the times, it's just a matter of enforcement and application. And the way that I see this, I see UWOs as one of the many tools within a much bigger arsenal that we have to tackle different instances of illicit finance that can be serious organized crime. UWOs in the UK, well, not that we have many examples, but the most successful one was in a serious organized crime case. We have other tools within our Proceeds of Crime Act that we can explore. I mentioned before, Section 6 of the Proceeds of Crime Act it's taxation, essentially. So these are obviously all these different tools. The problem is we need to use them, first of all, and second, use them properly. Tweaking the law is going to go and to get us so far. I think that the way that we need to look at the matter, also looking at the different challenges, there are 3 elements of response. We have legislation, we have regulation, and then we have enforcement. I also mentioned regulation because I think it was either Steph or Jeff, or actually maybe it was Andrew, or maybe everybody. People mention enablers. I don't like the term enablers, but it often happens that you have these individuals who can provide documentation, very well fabricated documentation that can justify the origin of the assets. So we have, if the kleptocrat or whatever person, the criminal, is going to have at their disposal a lot of different professions that are going to make their life very easy, especially when answering and responding to a UWO. These sectors need to be properly supervised, and that's regulation to you. Then we have law enforcement, we need specialists, we need resources, we need time. They often don't have time. Andrew mentioned this 180 days little close that there is in the UWO regime. How are you expecting a law enforcement officer that is already overworked and is already dealing with a lot of requests? How are you expecting to investigate properly such a complex transnational in nature case? So it's the three parts, and it requires a response that is not exclusively from public officials. Again, it's three different sectors and three different responses and different actors. So private sector, public sector, civil society in a way. We do our good. Sometimes we're very loud, not often. I mean, Jeff says, and Stefan definitely met some of us, so we do bang when we think that something is right. So obviously it requires a sort of a whole of a system approach. I know that it sounds a cliche, but actually it is that simple. We don't need to reinvent the wheel. We just need to apply the laws that we're talking about.
Thank you. And thank you for that, Maria. Stefan, I want to change tax a little bit and just get the U.S. perspective again with respect to asset forfeiture under the model that you explained earlier, sort of since 2000, how the U.S. has been conducting that. And I don't want to put words in your mouth. I don't want to say it's been successful, unsuccessful. It has had no impact. But how do you view when you sort of compare the U.S. model to what you're seeing around the world? What's working, what's not?
Well, it's a fair question. It's a question often asked, and it's also one that is unanswerable. In the United States, we do both civil and criminal forfeiture together, and they each accounts for about half of the receipts in a given year. And in a given year, our receipts are in the order of between $2 and $4 billion, depending on whether or not Bernie Madoff happens to be one of the defendants that you convicted in the year in question. If you recovered, let's say, $2 billion in a year from criminals, that's $2 billion that criminals don't have. If the Congress of the United States, in its wisdom, were to appropriate $2 billion to be given to criminals, I suspect we know what the impact on crime would be. And so I have to assume that if we take $2 billion away from criminals, it has the reverse impact, and it deters others from committing crimes and so forth. But how do you measure that? The only way to measure it, aside from anecdotally, is in the number of cases in which the money that's recovered is dispersed to victims. Victims have recovered billions of dollars in fraud proceeds and embezzlement proceeds and so forth as a consequence of the government having recovered the money through the forfeiture process. So my view is that, well, you can never say that you recovered all the money, and you can never say what would have happened if we had not recovered the money. It just logically makes sense that if we are recovering that quantity of money and getting it back to victims in cases where there are victims, that is a success, and that this pure logic suggests that if one criminal or one would-be criminal knows that his predecessor was not only sent to jail, but required to disgorge all of the boats and airplanes and money he set aside for his college tuition for his children, that maybe he will think twice about committing that crime.
Right. So thank you for that, Stefan. And maybe before we turn to the audience questions, we'll deal with one other topic, and that is, because it's on everybody's mind right now with the Russian invasion of the Ukraine, and certainly the Russian oligarchs and kleptocrats globally have been addressed a couple of times during this session as well. So maybe it's a more general question, though, and I'm gonna start with Andrew on this, but maybe a more general question around: is it working? Like, is it effective globally in terms of tackling this? We can come to Canada, Jeff, and lay bare all of the shortcomings that exist here. But let's start with how the landscape looks globally. what needs to happen or what is already happening that is just fantastic?
I think the question, is it working, is not the easiest one to answer, really. And if you're looking at whether or not these types of laws have effects on, the prevalence of corruption or kleptocracy and all these sorts of things, that's not really the easiest thing to say. And if you're going to look at the UK UWO and ask whether that has had an effect, I would argue it hasn't really had a big effect. They haven't really issued, they haven't issued any sort of confiscation orders that have resulted directly from a UWO. You have had one case where there was a settlement, so something was recovered. But in terms of actually, stopping kleptocrats from putting their assets into the UK, I would argue there hasn't really been a provable effect there. Whether or not these laws can have an effect, I would say yes. I think they do need to be stronger. I think, as we've already discussed quite a lot, I think you need to have the resources behind these laws to make sure that they can be effective. But also they need to be written in a way that they're going to be strong enough, and I think if you're looking at the UK one at the moment, I'm not sure it's really there yet. And I've mentioned it already like 2 or 3 times. If you do reverse the burden of proof, I think that will have a bigger effect on kleptocrats and how easily they can put their assets in certain jurisdictions. If you look at, just to give an example, this doesn't really relate to kleptocrats, but it relates maybe to corruption, which is basically the same topic. And if you look at Kenya, Kenya is a jurisdiction, it's not really well known that they actually have a civil unexplained wealth law. And they've had this on their books for quite a while, but they haven't really had any success with it. It took them quite a long time to get their first case through. And the first case went through maybe 2 or 3 years ago, right? And since this case has gone through the entire process of the court and a precedent has been set, Kenya has managed to use this particular law more effectively almost than any other law in Kenya to fight corruption. And they've gotten back millions and millions and millions in what is no doubt the proceeds of corruption. And so I think if you do introduce the right law, you do resource it correctly, you do have the political will to actually use it, then I think the effect that these laws can have could be huge. At the moment, I'm not sure, especially in the context of oligarchs and kleptocracy, I'm not sure it's having the effect that we would like it to, but I think it can. I think it can.
Thanks for that, Andrew. I don't know, Maria, if you've got anything to add on this topic.
Yeah, I think that, what Andrew said is fair, especially when talking about the UK. What happens when we mention the threaded word of oligarchs, I think that then a second issue comes to mind, that is the matter of sanctions. So what Jeff described at the beginning, the new amendments to is it SAMA? Yeah, okay, I never remember the Canadian term. But what policymakers have tried to do over the past months is essentially linking a matter of foreign policy to a matter of criminal justice and criminal law. So you have a sanction designation that it's very, very political in itself. It has a very lower threshold of evidentiary burden as well. So you want to use that for 2 purposes, essentially. On one side, you want to make and hold the oligarchs accountable for their association with the Kremlin and because of Kremlin's actions in Ukraine. But at the same time, these oligarchs are also somehow, they do belong to the category of kleptocrats or generally speaking of corrupt elites. And so what do? Do you get them for that original corruption, or do you get them because of what's been happening in Ukraine? And I think that that's a question that we still don't really know how to answer. Canada's tried. I'm not really seeing it going anywhere. Maybe it's going to be, successful at some point. I'm honestly a bit wary about mixing issues and mixing geopolitics with issues of asset recovery because, I come from a country where the rule of law was a bit undermined back in the days, and now we're finally, well, somehow, sometimes not really, but we know that the problems that arise when human rights are trumped. So that's for another day, for another discussion. But generally speaking, as Andrew said, UWOs, they need to be strengthened, they need to be bolder, they need to be properly resourced, they need to be accompanied by much more efforts by everybody, every actor essentially in the asset recovery equation.
Thanks for that, Stefan. Just to get the U.S. Data. The U.S. from a data point is extremely important. You have a very strong, robust sanctions regime that the rest of the world pays very close attention to, given everybody's connections to the U.S. economy.
Well, yes. I mean, in the context of oligarchs and the intersection of oligarch resources and unexplained wealth orders, the first problem we've encountered is that an oligarch's wealth is seldom unexplained. He's the one more likely to be able to explain the source of his wealth than anyone else we've been talking about today, better than a drug dealer or an embezzler or a corrupt politician in a developing country. He can show that he has a control of the oil and gas business in Kazakhstan or some such thing. So unexplained wealth orders don't help you very much with respect to oligarchs. What you do want to be able to do with respect to oligarchs, and certainly if you're in our system where you have to prove a crime, is make it possible to use the evasion of the sanctions as the crime that is the predicate for the forfeiture, as opposed to the original source of his perhaps illegal wealth in Russia. Maria and I have debated this at various conferences, and we have different view. My view is that while it would be nice to be able to go after the person's assets in the United States or Canada or the UK because he is a corrupt Russian politician or embezzler or something else, we're never going to be able to prove that. But if we sanction him and tell him he cannot use the U.S. financial system, and then he uses the U.S. financial system to maintain his yacht or to purchase a Boeing airplane for his personal transportation, which these people have done, then we can use the fact that he violated the sanctions as the basis for the confiscation and not have to get into the underlying crime. And while it may be that the sanction is because of what Russia is doing in Ukraine or what Russia did in Crimea, or in another context, what the North Koreans are doing to develop a nuclear weapons program, or what the Iranians are doing to develop a nuclear weapons program, all of which has foreign policy bases or groundings. Nevertheless, it's a violation of the criminal law to violate the sanctions. And that turns out to be the method that the U.S. has been using to bring civil forfeiture actions, beginning with seizures of yachts, airplanes, and other wealth of the Russian oligarchs.
Thanks for that, Stefan. So Jeff, round us out with the Canadian perspective. How's this going in Canada?
Sure. And it's not just Maria that disagrees with Steph on. So the Americans, I will say, because of the primacy of the American dollar and because of the U.S. financial system, the only way for international commerce to occur is for you, if you're wherever, Russia, Europe, to have a correspondent banking account in the United States. And so that puts the Americans in a unique position where they can deal with a sanctioned individual where they didn't disclose to their bank they were sanctioned, and it's a fraud on the U.S. system because of that corresponding bank account. It's a lot more complicated, and there's a lot more that the Americans are doing. But I just would say that there's something we probably can't do in Europe, and we probably can't do in Canada. On kleptocrats, the problem that I think we find ourselves in, and the UK certainly does too, is that we have really welcomed the money, right? We've said we've had there's kleptocrats that have met the prince and donated to Cambridge University in England and so on and so forth. We really welcome that money. Now, all of a sudden, because of a foreign policy event, a horrible one, the invasion of Ukraine, we're suddenly saying, well, we don't welcome that money anymore. And the systems that we have for unwelcome money are not really built for where we're trying to take it. And, it's for sure, we don't want someone who's making money from drug dealing. That's always been unwelcome, and we have the system for that. And so when it comes to dealing with kleptocrats' assets, we have doctrines of state immunity, and we have a presumption against retrospective application of law. That's a mouthful. And so those kinds of things pose really, really big challenges. What I would just say in my concluding remarks, two things. There's some really interesting questions in the Q&A around data. And we are terrible, and I mean really terrible in Canada at data. I've been involved in the mutual evaluation process. And, for example, we have possession of proceeds of crime as a criminal code offense. Well, that's meant as not only for a launderer, but it's also meant for someone that's fencing stolen goods. And we don't really divide the two. And we have the different jurisdictional silos, and they don't all talk to each other, and they don't all report things and deal with things in the same way. So that one of the questions that Cullen grapple with, how much money laundering is there? How much crime is there? No one knows. And when you actually look at, for example, the Criminal Service of Canada estimation, the margin of error is in the billions of dollars. So it is something, I know academics have often said we need more. I agree with them. We do need more. My last thought is this. When it comes to organized crime works a little bit like a McDonald's in the sense that you have a lot of low-level people who pick up the garbage and serve you at the counter, and they're poorly paid. And if you got rid of any of those people, so what? It's organized crime actors insulate themselves. They go up the food chain, but what they do get is the money. And that's, to me, what the most important thing about forfeiture, asset forfeiture, civil criminal, is it works you up the food chain. Because if you're just knocking off a bunch of money couriers, you're not really hurting a Mexican cartel. But if you're working your way up the food chain and getting at their mansions and their yachts, and the same goes for oligarchs, then you're actually having a measurable effect, and it's a good use of your resources. So
thanks.
I'll close with
Thanks for that, Jeff. We got time for one more question from the audience. I'm going to let Andrew and Maria battle over who's going to answer this one. But basically, it's looking at a system where, if we step back for a moment, and I don't know how many of us have read the Global Financial Integrity Annual Report on illicit financial flows around the world. So the latest estimate was about $1.2 trillion annually of illicit financial flows, most of it going from the developing economies into the developed economies. And so you've got this enormous sort of reallocation of wealth that's going on an annual basis every year. But to tackle that, that's going from, and keep in mind, a jurisdiction like Canada or the US or Australia or the UK, we are multicultural. And so we have large communities from all of these countries from which this wealth is being shifted into economies such as Canada, Australia, the US, the UK. But to tackle that specifically can result in calls of racism or calls of, unfairly targeting specific identifiable minority groups around their wealth. How do you deal with that? How does a jurisdiction deal with that effectively? Don't jump in all at once.
I'll jump in, but I'm already regretting it, to be honest. I don't think there is an easy answer to that. I do understand that the Cullen Commission report has sort of come out of maybe the context that you're referring to here is the amount of Chinese money that's flowing through the casinos in Canada at the moment, and how that gets mixed in with criminal money and all these sorts of things. And to be honest, I don't have an answer to that. I think the number one priority of the state should obviously be to enforce a law fairly. If certain issues are happening relating to certain cultures or people of certain nationalities, as long as the state is really making its best efforts to approach this issue with a little bit of objectivity and is simply trying to enforce a law that exists fairly, then it's not really fair to accuse the state of racism. And I think, maybe that's quite a simple answer, and it definitely doesn't take into account a lot of the intricacies that would go into criminal justice policy and what sort of laws should be targeted and which sort of areas in the country should be targeted and all this sort of stuff. But I think the priority really should be for the state to enforce the law with as much fairness as they possibly can. I think, also take into account, I am white, male, Christian. I'm probably not the best person to really provide comments on this exact topic, but I think as long as the state is doing that, it does make it hard to criticize them on the basis of racism. They're never going to apply the law perfectly, but as long as they can be seen to be applying the law fairly, I think that's a start, at least.
Thanks for that, Andrew, and thanks for showing the bravery of tackling that one. And Maria, thanks for agreeing to come in and rescue Andrew in case he said anything that was untoward. But you've got 60 seconds.
Nothing, then I am happy to just say this: as long as the laws that we look at, like that we draft, are human rights and rule of law compliance, then I think that we're doing the job right.
Thanks, Maria. And in the interest, and we're coming to an end of this, I want to offer my gratitude to Jeff and Maria and Stefan and Andrew for their time. I mean, for Andrew and Maria, it's quite early. I don't know, it's probably late for Maria. I don't know what time it is for you, Andrew, but the reality is you've devoted a lot of time and energy to this effort, and we very much appreciate it. And what I want to do is just for some closing remarks from the current chair of Transparency International Canada, Susan Côté-Freeman. So Susan, over to you to sort of wrap us up.
Well, what can I say? Wow, this was a really interesting deep dive into a very, very topical subject. So congratulations to the panel, and for you, Peter, for your expert moderation. I think just off the top of my head, what really struck me in the discussion about what would, robust, unexplained wealth order legislation would look like, there are a lot of views, obviously, and there's a lot of room for discussion around what would make them more robust. But what struck me was some of the old problems that crop up and that were mentioned by Maria and many others. And it's the issue of, adequate resources, of enforcement, of communication, the problem with enablers, the lack of transparency around all of this. And these issues actually cross all the discussions we have around corruption. So let's not forget about them. That would be my parting comment. And so with that, I would just like to thank all of you once again for sharing your expert views. I hope the participants found it as content rich as I did. And I also want to thank ACLP, and in particular, John Ritchie and Joe Weiler, for putting these series together. And I look forward to installment number 4 on the Cullen Commission. So thank you very much to all of you.